Hi, I hope you've been well. Fiona is my name. Today, I want us to discuss something to do with the Landlord Tenant Act of 2022. If you're new to this account, please give me a follow, like, and go and view all the other videos which are up and running. If you don't, you may never see me on your account again. Now, in 2022, a new law was passed, which is called the Landlord and Tenant Act. And in 2023, we saw a case where the sections of that act were applied. In the case of Nalobega Ruth versus DL Properties and Francis Drake Lubega, this is a matter where Ruth had sued Drake Lubega and DL Properties for conversion, detenue, and trover. And what that means is that she was alleging that the defendants had opened and taken her goods without her consent and had refused to release them. The defendants' facts were that Ruth was a tenant and she was in default for more than 6 months, and she had locked the premises where her goods were kept, and she had kind of disappeared. So when they went to court, the judge, Honorable Sekana Musa, is the one who gave judgment in that matter, made some key points that I thought that we could share. Number one, he made reference to Section 29 of the Landlord and Tenant Act, which provides that where a tenant has defaulted in paying rent, they can apply to a court of competent jurisdiction to recover the rent owed. However, where the default continues for more than 30 days, then the landlord has the right to re-enter the premises and take possession of the premises and remove all the properties of the defaulting tenant, as long as there's an LC official present and the police is present as well. Now, he also went on to note that it is a bad practice for a defaulting tenant to lock the premises of a landlord, disappear, and expect the landlord to keep waiting for him or her until he resurfaces to open. Further, he noted that the landlord whose premises have been locked by an absconding tenant who is not even paying the rent, if the default has been for such a reasonable time, then the landlord is at liberty to break into the premises so that he can mitigate the losses. Now, back to the case that I referred to and where these discussions were made. This lady had defaulted for 6 months, and for all those 6 months she hadn't paid rent. Now, because the default was continuing, and for after a period of 6 months, I think probably she had information that we were going to break in, she paid her rent the day after they had broken in and had brought that as evidence to court to show that for her she had paid. But on court viewing the evidence, which was presented by both the plaintiff and the defendants, they found that she was actually at default and had left no choice for the landlord except to break and remove her properties, which were stored at a different place. And when she made a police report, those properties of hers were transported and put at the police. What is the implication of that for you and I, who are either tenants or landlord? It simply means that we should all try to, be reasonable and try to comply, so that we don't really inconvenience our landlords, because as you can see, the law has given them the right to come and break into the house if for any reason you have decided you've defaulted, and then on top of that you have disappeared. Now, if that default continues for more than 30 days, the landlord has the right to come and break into the premises, as long as there are the local area officials present and the police is present, and there is nothing you as tenant can do. So I hope this information is very helpful for you. I hope to see you soon.